Paul, welcome to Constituting America's Constitutional Chats podcast. We're going to ask if you'll just give us some opening comments, about 8 minutes till 2:15 on the Eighth Amendment, and then we'll go to questions.
Great. Thank you, Kathy. It's a pleasure to be with you. It's also just a delight to be able to support and be a part of Constituting America. This is an outstanding initiative. I think more than ever, we need to be encouraging citizens to understand our Constitution, understand its content and its meaning, and be able to really participate in the public square in an informed way. So I get the opportunity to talk about the Eighth Amendment today. This is the shortest of all of the amendments, of the 27 amendments of the Bill of Rights. It was part, of course, the initial group of amendments that we call the Bill of Rights. So even though it's the shortest, with only 16 words, it's actually a very controversial one that literally involves life and death questions. So there are three protections in the Eighth Amendment. There's a protection against excessive bail requirements, money paid in order to be released from custody pending trial before conviction. There's a protection against excessive fines. So only a fiscal penalty would be involved there. And then thirdly, the infliction of cruel and unusual punishment. So those are the three protections of the amendment. Now, the amendment applies both to the federal and state governments. And when it comes to bail and fines, basically states, the federal government and states have enacted laws to create systems for deciding what a fine would be for various crimes or for various offenses. They could be civil penalties, such as government agencies imposing fines. And federal and state governments have enacted laws relating to bail requirements. So courts haven't needed to use the Eighth Amendment to protect the public when it comes to fines and bail, largely because there's a statutory system in place, and they've deferred to those statutes to protect these rights. So most of the action on the Eighth Amendment is around the third piece, cruel and unusual punishment. Now, there are 6 issues that are the most significant litigated questions about cruel and unusual punishment. And very quickly, those 6 issues are the discrimination in the application of capital punishment. That's number one. Another one would be who would be eligible for the death penalty. We refer to that as death eligible defendants. There's also crimes that would be subject to the death penalty or death eligible crimes. Those are 3 things. Then we have method of execution as a 4th issue. Fifthly, life in prison without parole has been the subject of a lot of litigation and disagreement. And then finally, one that's probably not thought of as fitting on the Eighth Amendment, that's inhumane prison conditions. And defendants or incarcerated people will often file lawsuits claiming that an Eighth Amendment protection has been violated based upon the conditions of confinement. So those are the 6 main issues. Now, let me just speak in a little more detail on a few of them. One of them is, of course, the first one on the issue of the disproportionate or the discriminatory application of the death penalty. The major case was called Furman versus Georgia in 1972. And the argument was that the death penalty was arbitrarily and with discrimination being applied to various cases, so that defendants who were similarly situated were not being subject to capital punishment. And so the court actually, in 1972 in Furman versus Georgia, established a moratorium on the imposition of the death penalty. And for 4 years, in no place in America was capital punishment permitted. In 1976, in a case called Gregg versus Georgia, the Supreme Court said that the death penalty could be imposed. The moratorium was lifted, so long as procedures were established that removed as much of the arbitrariness and potential discrimination as possible. So during those 4 years, states came up with a system of procedures where after the trial of the defendant, there would be a separate trial, same jury, but a new trial with evidence that shows how the case was more aggravated, some aggravating factors with regard to the underlying crime. And the defendant has an opportunity to demonstrate mitigating factors, a wide range of mitigating factors. And then the jury takes all of the evidence on the aggravating side and on the mitigating side, weighs them, and if the aggravation outweighs the mitigating factors, then the death penalty can be imposed. That's a procedure that goes on everywhere in the federal and state system since Gregg versus Georgia. So that's the issue of how is the death penalty actually applied to try to avoid arbitrary or discriminatory application. Now, with regard to death-eligible crimes, the Eighth Amendment does not permit capital punishment in cases of rape, or really any crimes now that don't result in death. So these, again, are decisions that have been made. Coker versus Georgia was the decision that ruled out rape as a possibility for the death penalty. So death-eligible crimes have been limited to the taking of life. And when it comes to death-eligible defendants, now juveniles are prohibited under the cruel and unusual punishment protection from being subject to the death penalty if the crime occurred while the defendant was a juvenile under 18, and mentally disabled persons may not be executed. So the court has focused on non-juvenile murder cases and those who are mentally competent, essentially, to summarize who's eligible and who's not. And then on the issue of life without the possibility of parole, there have been basically a half dozen or more Supreme Court cases from the early 2000s to about 2012 that narrowed increasingly how mandatory life would be applied to juveniles. And the sum of it all is that now juveniles may not be automatically sentenced to life without parole in cases that don't involve homicide, in cases that involve homicide, and in cases that don't involve homicide, they may not be subject to life without parole. So life without parole is only available on a case-by-case basis when homicide is the crime for those who are under the age of 18. So the issue of life in prison is kind of the other category aside from the death penalty itself when it comes to cruel and unusual punishment protection. And finally, I think the two big questions that remain are who decides what is cruel and unusual punishment, and on what basis is that decided? And in the last 20 years, there's been a lot of disagreement with the Supreme Court about this question, because one side says that the standards for deciding what's cruel and unusual evolve over time. This is referred to as the evolving standard of decency that marks the progress of a maturing society. And that evolving standard of decency is the test by which life in prison for juveniles, or the execution of those who are mentally disabled, or juveniles as another possibility. That's the way in which the court has changed the death-eligible categories and so forth. And that's in opposition to a view that we might call the originalist view, which says that we would look to the language of the Eighth Amendment at the time it was enacted, at which time death penalty was permitted for some of the cases that have been ruled out as possibilities now. And so it's sort of the classic example of a living constitution on one side versus the originalism view on the other, but applied to capital punishment. And of course, who decides? That's the big issue, because when the court makes the decision, it's limited to the 9 justices. as opposed to state legislative bodies where most public policy is decided. And that's the ongoing debate of the day. So Kathy, that's a quick overview of what's packed into the Eighth Amendment. And I hope that was somewhat clear, but
Yeah.
I'm sure there's a very quick and a lot of questions you might have about that.
That was a great summary. Thank you so much. And we're just so honored to have you with us today. And I'm going to toss it over to Janine.
Yes, thank you, Paul. That was really, really awesome, and very, as Kathy says, very coherent. But since I'm not of a legally trained mind, and a lot of our listeners aren't, because a lot of our listeners are in school, elementary, middle, and high school. Can we go over a few things again? All right. So the six. You started with the six. What was that again?
Yeah, so those are the sorts, I call them the primary issues that have been subject of litigation and Supreme Court decisions on the Eighth Amendment. So there are six things that.
And what were those again?
Okay,
Right.
The first is the question of discrimination in the application of the death penalty. Who's actually subject to it? And whether or not, in particular, there's for example, is there racial discrimination in relation to when the death penalty is imposed? So there are the major cases associated with that question of how it is applied to avoid arbitrary and discriminatory application. The second issue has to do with the offenses that would be included. We call those death eligible offenses. What can a person be executed for? The third is who can be executed. So death eligible defendants. So you have the crimes and the defendants. And then the last three are sort of just three other issues that come up. The method of execution. There've been a number of cases about how a person would be subject to the death penalty. Whether or not life without parole, the possibility of parole, is cruel and unusual. And then finally, questions about the prison conditions and whether or not they're inhumane, and inhumane prison condition might be overcrowding or some other kind of unusual setting that is so difficult that actually the court has recognized it as violating the Eighth Amendment. So those are the six primary issues that get a lot of attention around the Eighth Amendment.
And you said there were three aspects of the Eighth Amendment. And the first two we don't worry about so much anymore. And why is that again?
Well, it's because when we ask the question, what is an excessive fine? That's a very difficult, question to decide with any specificity. So take, for example, a fine of $100,000 for some type of fraudulent act. Now, legislative bodies, both federal and state, will create the offenses and say that the penalty should be twice the loss of a victim, or maybe 3 times the loss, and have ways of calculating what the fine would be. And the courts have looked at those different systems and said those all seem reasonable, and there's no argument that it's an excessive fine as long as it's been thought through carefully by legislative bodies. And so if someone wanted to challenge a fine and claim that it violates the Eighth Amendment, it'd be very difficult, because the court would have a hard time coming up with, say, a better system for deciding a proportional or non-excessive fine than what the state and federal legislative bodies have already done. That's why the courts essentially defer to those systems for imposing fines and for setting bail, rather than have lots of litigation around whether or not the Eighth Amendment has been violated.
So those excessive fines that are decided by state and federal legislatures, how does that work if states and federal are doing it?
Well, I was actually counsel for the crime subcommittee of the House of Representatives for 8 years. So I wrote a lot of laws that not only establish what would be prohibited. Let's take drug laws, for example. What type of drug laws would, drug violations would be prohibited by federal law. What the period of incarceration would be up to a certain maximum, say 10 years or 20 years, whatever it might be, and the fine that the court could impose. So that when legislative bodies create criminal laws and civil laws for purposes of enforcement, they come with penalties, both confinement penalties and financial penalties. That's what I'm referring to, is the court looks at those financial penalties and sees them as being essentially reasonable and within the protections of the Eighth Amendment.
But those were being written up on a federal level.
And at the state level too. So states do the same thing that the feds do in terms of writing criminal laws and create penalties for those violations. So it might be a criminal law associated with a major theft crime, and the penalty could be up to 10 years in prison and a fine of up to $100,000. And then when the court sentences the defendant, the court might say the defendant will receive a penalty of 5 years plus a fine of $100,000. And if the defendant appealed the case and said, "Oh, that's a violation of my Eighth Amendment protection against excessive fines," the courts are likely to say, "We're not going to second guess that statutory level of fine. We'll defer to that being a reasonable one, so it's not a violation of the Eighth Amendment." That's how it would work.
Interesting. Because you see a lot of the states doing very different things with fines so that would be on a state level. So what I'm trying to figure out is when in this instance is the federal in charge to trump state, and when state can trump federal, because I think that what we see around the country right now are different states are having, like California is very different than what Texas does and whatnot in regard to crime. So when do states get to make that decision, and when does the federal trump that?
Well, like so many other amendments in the Constitution, those relating to criminal law, states have different practices, different laws, but defendants can appeal to the Supreme Court if they think a federal constitutional issue has been violated by a state in its enforcement of law. So in this case, if a state imposes a certain penalty, let's take, for example, the issue of mandatory life for a juvenile. At some point in the early 2000s, juveniles sentenced to that kind of penalty might have been upheld by the state Supreme Court as being a reasonable penalty. But the defendant went on to the federal Supreme Court because it was a federal constitutional question, and the Supreme Court ruled that no, life in prison for a non-homicide crime was a violation of the Eighth Amendment, and they overturned the law that existed in that state. So when it comes to constitutional questions, the federal Supreme Court always has the last word, even as states will have different legal systems in place and different penalties and crimes and so forth. Constitutional questions will get ultimately resolved by the U.S. Supreme Court.
But when you were writing up those laws, weren't you doing that on a federal level?
That's right. And so they only apply to federal cases. And so it would be the states would have to create and enforce the equivalent laws at the state level, as they do.
Okay. All right. Amazing. Well, I have limited time. I could ask so many questions, but I do want to go to, hopefully someone is going to ask about what's happening in the states today in regard to these excessive fines and whatnot being sort of taken advantage of to the point that people aren't having any punishments at all by claiming it's excessive. I think that's what we see happening. So I guess I'll ask that question, and you can juxtaposition that in a way back, because there's a lot of talk of the originalist view of this amendment. So juxtaposition that with what we're seeing it seems like they're saying, oh, that crime and punishment is too intense for just holding a knife at someone's face. And so suddenly there's no punishment for that. So they seem to be taking advantage of this a little bit.
Sure. Well, the question of leniency by any particular judge or any particular area of judicial system within the country is different than making a successful constitutional argument. So in a typical case that the defendant is dealing with the local judge and the sentencing authority that the local judge has, and it does involve any case issue that's going to go to the Supreme Court. And if we perceive that there's a soft on crime attitude in existence, it's because too many judicial systems, too many judges are not taking violent crime in particular seriously enough. And there was too much tolerance, or perhaps the states, like in places such as California, the states have passed laws that have reduced penalties and tied the court's hands or the prosecutor's hands in trying to incapacitate violent people for longer periods of time. So, and that's the same thing with bail reform, where we see political movements from the left attempting to reduce or eliminate bail requirements, setting free then those who have been accused of a crime and making us less safe if those individuals commit new crimes while they're out on bail. They're actually not even really out on bail, but they're out on some type of release condition before a trial and a possible sentence is imposed. So these problems have existed, and they tend to run in cycles. The public puts up with them only for so long, and then we start to see a crackdown on particularly violent crime and more substantial prison sentences. And we've been through a good period of that in the 90s into the 2000s, and now we're seeing, unfortunately, a softening of the system and a lot of repeat offenders causing unnecessary harm to people.
And what would in my last question here, the originalist view, what would the originalist view be on all of this?
Well, the originalists would look at the states as being empowered to establish appropriate crimes and penalties. It may not address, the originalist view may not address the leniency of a local judge. In fact, it wouldn't. But what it would respect is how the constitutional provisions would apply to state law enforcement. So let's take again the issue of life sentences for a violent juvenile offender. Now, if it's non-homicide, the Supreme Court has said that it's a violation of the Eighth Amendment to impose a mandatory life in prison punishment on, say, a 17-year-old who has committed a repeat number of violent crimes, but not homicide. Originalists would say that that state law that would allow for a life sentence should be allowed to exist, because the original view of the Eighth Amendment would not have restricted that in the first place. That's more restricted now by this sort of modern sense of the evolving standards of decency. And in the actual case where life in prison was considered or concluded to be unconstitutional, the opinion actually cites changing state laws, international standards, and general concerns about proportionality. So it's a more of a flexible and shifting view of what the Eighth Amendment protects. The originalists would say that at the time it was established, this is not something that would have been prohibited. And that's the essence of the debate.
Okay. Really, really interesting. Thank you. I have to pass. I could talk all day, but I have to pass. So Tova will have wonderful questions for you now. Thank you so much, Mr. McNulty.
You're welcome.
Thank you, Janine. Thank you, Mr. McNulty, for being here. This was a really fascinating overview. You touched on so much. I kind of wanted to take a slightly different track to my question, which is you mentioned this idea of juvenile being a separate category that, has a different standard applied to in terms of like excessive punishment, cruel and unusual punishment. So I was curious if you could talk a bit about the history of this idea of juvenile as a separate category that has a separate standard.
Yeah.
Constitutional standard applied to it.
Sure. Well, when you look at the Supreme Court decisions, and these are rather recent decisions in the sense that they're post-2000 decisions, a juvenile is looked at as, generally speaking, someone who's less culpable than an adult when it comes to the offense itself. So that's one issue, culpability. Does a juvenile fully appreciate the situation at hand? Can the juvenile, for example, exercise the same type of freedom to extract him or herself from the circumstances? And the questions of whether or not the purpose of punishment, such as retribution and deterrence, would be well served by the life in prison sentence. So Justice Kennedy, in a case called Roper versus Simmons, outlined these kinds of considerations as to why juveniles should be viewed as kind of a separate category from all other offenders. Now, Justice Scalia wrote an incredible dissent where he step by step criticized all those categories that were cited in the majority opinion. But that opinion pretty well summarizes why juveniles have been put into this special category of protection under the Eighth Amendment.
Very interesting. And it's interesting to me that there are certain cases under law where we can apply a different constitutional standard. For instance, as you mentioned, juvenile or mental ability. But it's interesting that there are other categories where that's kind of considered off limits. Race now, although it didn't used to be. Gender to a large extent, although not completely. So I'm just curious, could you comment and reflect on this difference? How certain categories have come to be seen as acceptable to have different standards, whereas others are considered off limits, and how that developed in our legal understanding.
Well, that's an interesting question because you're right. It all depends on the context as to whether or not discrimination is actually acceptable or not acceptable. And so, under the 14th Amendment, that's where most of the litigation is focused that has to do with that second category you're talking about, discrimination based upon gender or race or religion, ethnicity, those types of things. And there the issues are, I've been discriminated against. I haven't been, benefited from the equal protection of the 14th Amendment or the due process protection. So, cases are all about who's making the claim and what's the basis for the claim. So there the basis is, I'm subject to discrimination. On the Eighth Amendment, the juvenile is saying, I want to be subject to discrimination. I want to have my set of circumstances treated as differently from, all offenders because of these factors. And even though you're absolutely right, there's sort of a strange inconsistency there. It's all about, who's trying to avail themselves of the protection of the Constitution, and how does that particular amendment work? And so there are other places in the Bill of Rights where an individual is looking for special treatment, you might say, because of a set of circumstances that would distinguish him or her from the general population. But this juvenile question on the Eighth Amendment is probably the clearest one. And now it's actually pretty well settled law. It was not so settled in the early 2000s when the initial cases were coming along. But now the court is pretty comfortable with the idea that juveniles are in this distinct category and are going to be treated differently for purposes of Eighth Amendment protection.
That's really fascinating, and it'll be interesting to see what categories are added or taken away,
Yeah, that's
as
interesting.
you keep
I don't
going.
know what's left, but I guess there's always a possibility. At the end of the day, defense lawyers are looking to take advantage of every constitutional claim they can think of. And when it comes to the Eighth Amendment, the goal of those in death penalty cases in particular is to try to stop the imposition of the death penalty in every conceivable way legally possible. And so that's why we have had in this century, the mentally disabled came first. That was Atkins versus Virginia. And once that decision was made, it became easier for the juvenile to make a similar claim. I'm not aware of any other category, that's on the brink of trying to get
I guess I was
somehow
curious.
protected.
One category that maybe occurred to me would be, and I'm not familiar if this has been attempted, but potentially social class or income. Because I don't know, for instance, in my home state of Illinois, this kind of brings me to my next question. There's a big debate about cash bail, and whether having cash bail is sort of discriminatory against people
Mhm.
who have a lower socioeconomic status, and kind of emphasizing a shift to other methods of determining bail, maybe based on an analysis of like flight risk, that sort of thing. So I wonder if maybe social class or socioeconomic status could be, maybe that's the next front to be considered a separate category, both in the
Yeah.
consideration of bail, but maybe also some analysis of if you're in like a poverty-stricken situation, maybe you're more likely to commit certain crimes. I don't know. I'm just curious. Do you have any thoughts on that?
Well, it's an interesting point. The effort, in a sense, has been made on the death penalty because part of what's going on in Furman versus Georgia, where the moratorium was imposed, and then what happened over the course of 4 years before it was allowed to, that the capital punishment was resumed, was this idea that the discrimination involved economic disadvantages as well. So it wasn't just sort of racism that might be the reason why one jury would impose a death penalty, but also the inability of an individual to have the right attorneys and to put forward the best case. Supreme Court, I think, has pretty well made it clear that if these procedures are in place, the court's not going to go further and say that, there's an income line or something of that sort where the death penalty wouldn't be imposed. I'd be very surprised if that kind of standard could come along. But you're right, that's being used certainly when it comes to bail reform, and it's probably most used when it comes just to asking courts to be lenient and to say, well, I came up in a hardship situation. I didn't have the parenting, I didn't have the benefits, and therefore I need to, essentially have the mercy of the court. And in many, every day, essentially, that argument has some effectiveness when it comes to persuading the court to impose a lighter sentence.
Yeah, fascinating. And then my last question, kind of separate, is this idea of civil forfeiture, where my understanding is that the government has the right to take property based on it being linked to a crime, even if you haven't necessarily been convicted of that crime. And I know that's a very controversial thing that the government can do. So I'm curious about the difference in law between fines and confiscation of property. And, does a fine have to be considered money? And, could civil forfeiture be considered excessive fines?
It could. I think that the easier way that civil forfeitures have been attacked is through due process of law. Was there a sufficient finding of fault that warranted the confiscation and forfeiture of property? Now, here's another example where the courts have looked to the legislative bodies to sort of set up the system for how civil forfeiture would work. So, having worked on civil forfeiture a lot when I was on the Hill and with the crime subcommittee, I watched this process play out, where it wasn't so much judicial relief, but political pressure and cases where, say, someone lost a home for what seemed to be a very minor connection to a drug trafficking crime. And these sort of hardship cases began to actually persuade even conservative members of Congress that the federal laws on forfeiture, especially civil forfeiture, had gone too far. And so there was civil forfeiture reform. It's funny you say you're from Illinois, because I used to work for a congressman named Henry Hyde, who was the chairman of the House Judiciary Committee. And he was actually, even though he was my boss and I was pro forfeiture, he led the charge in reforming civil forfeiture, because he came to believe that it was too confiscatory or it was too penalizing. And so, but it wasn't an Eighth Amendment claim at the end of the day. It was more of a political case. And he was able to muster the votes to get some relief on the civil forfeiture procedure process, to give the property owner more protection in those cases. So it hasn't yet been singled out as an excessive fine, to my knowledge, as opposed to the pressure that's been put on legislative bodies.
Well, thank you so much. This has been really, really fascinating. Thank you for sharing all your expertise with us. And now I will pass on my questions to Jewel and Jordan.
Great, thank you.
So I'm going to say I'll string some things together, and then you can comment on them however you wish, just for the sake of time, instead of splitting them up into different questions. So we talked about different versions of interpreting the law and the Constitution, and sometimes it really gets me thinking. So we talk about it. It seems as if often, instead of having to address really what the words say, we talk about like a living constitution, so that those who don't agree with what the words clearly mean do not have to try to get an amendment changed, because it's just a harder process. Mm-hmm. It seems as if we do better to debate the words as they are written, and then if we come out to believing something different, champion the cause that you want the words changed. Mm-hmm. The words cruel and unusual, I know that while they are vague, they do have meanings. And if we talk about the crimes which we are given different punishments for, our founders often, not in mob lynchings and things like that, but often it looked at a proportionality and natural law, and trying to, and if someone is willing to take another's life or take property that could cause them their loss of life, the capital punishment was often the remedy of the state in that case. Now we have those who are non-violent criminals, who are often put in situations like they'll be in solitary confinement, not for anything violent in the prison, but they'll be 24 hours a day light, no windows, exercise once every 30 days. And then we have brought up, when we look at these non-violent criminals who are put in those situations, we conflate their situation with violent criminals who are then released, early. So we have this strange debate going on, where those on the right often are saying we need to be harder on, we need to protect the public from violent criminals, as we continually see violent criminals are getting out and committing new crime. And we say, what happened? And we say we had him and we let him go. But at the end of the same time, we have non-violent criminals seemingly having their constitutional rights infringed upon, because they're put in situations like a solitary confinement situation for a non-violent crime, for a crime which then it goes to the next problem of, is it a radical department of justice that put them in there as a political prisoner in the first place? So I guess you could comment on that quickly, because I know that many of our listeners their minds are going to be thinking about these two issues, where we have January 6 defendants we see their stories, why they're there, and we see the way that they've been treated. But at the same time, we see people who were brought in for a violent crime, let out, and went on to commit more violent crimes.
Well, let me comment on the nonviolent offender situation you described. I think we all know about this other problem of repeat offenders, short sentences, getting out, coming back again, that kind of thing. And that occurs, by the way, a lot at the juvenile level. And juveniles essentially learn through the criminal justice system that there's no accountability until they commit a crime that is so significant that there's longer prison. But unfortunately, the system doesn't teach much about deterrence through allowing especially young offenders go through the system over and over again. Now, on the nonviolent side, then in relation to the Eighth Amendment, if someone is being held in isolation over a long period of time, and it's not connected to the prison or the jail, there's of course difference between those two types of confinements, but it's not connected to some type of protective interest that could be demonstrated in court as being legitimate, then it could be a violation of the Eighth Amendment, because it would be seen as cruel and unusual type of confinement as one of those 6 categories I mentioned. In my own experience, which predates all the January 6th type of enforcement, but going back to my time at the Department of Justice, the only people we had in isolation were violent criminals, and particularly they were terrorists and the major spies. And I was involved in Eastern Virginia in the prosecution of a lot of these cases. And in the federal system, there are places of confinement for the most serious offenders we have in the whole federal prison system that are fit the description you provided of the sort of isolation and limited amount of time outside the cell and so forth. Now, if individuals are being held in that way for offenses that are not of the nature that I saw with the prosecution of, say, the 9/11 terrorist offenses, then the question would be, are they being represented sufficiently to bring those claims forward and to have a court look at the circumstances of incarceration? And I can't speak to those facts because I'm not personally aware of them, but there is an Eighth Amendment issue at stake there if that's the nature of the confinement.
Okay, thank you. Thanks for trying to piece that apart. I know it was long. And Jordan's got a question.
That's all right. That's all right. Very interesting question.
Could you just tell me a little bit about how bail is assigned? Like, what is the process? Is it a strict, check off the boxes type of thing? What do they look at?
Yeah. Well, what happens is at the time of arraignment, when the charges made against the defendant, the prosecuting authority, whether that's the federal U.S. attorney or the state district attorney, requests that the court set a bail at a certain amount, or asks for a confinement of the defendant pending trial, because the individual is so violent that he shouldn't be released pre-trial. What the prosecution has to provide is, the level of risk has to be measured. What's the risk that the person will not return for trial? That's the primary issue. And then the second issue is whether or not there would even be reoffense occurred during that pretrial time. And the bail amount is set in part on that risk level. And if there's great risk that an individual will not return for trial, then bail is set very high. Court has complete discretion in most cases as to how high that's set, but would set it high because either they're not going to be able to make bail and they'll be held, or they will have to work through a bail bondsman and generally have to pay 10%. And if they don't show up, then they'll be liable for the bail amount itself. So historically, it's been a pretty good system for ensuring that defendants show up again for trial if they're released. Does that help?
Yes, it does. Thank you. I think we have to move to some audience questions now.
Okay.
But thank you very much for your time.
Sure.
Well, thank you, Jewel and Jorn and Tova and Janine. Y'all have had some great questions today. And before we go to the audience questions, we want to give a shout out to our students and teachers who are watching with us today. We have Hope Mucklow, who has some homeschool students watching, Cherie Stiegel with homeschool students, D'Angela Hines at Emerald Coast Christian Academy with students watching, Cami Waynaus with homeschool students watching, and James Evans in Arizona with 30 students watching. So thank you. And if you are a teacher or a student who are watching and I didn't mention your name, feel free to type in the Q&A and we'll try to give you a shout out before the program concludes. We also want to thank our listeners in Las Vegas's KKVV 1060 AM. This podcast airs Monday evenings at 6 p.m. Pacific on Las Vegas's KKVV. So thank you to all our listeners in Las Vegas. So Paul, our first question comes from, let's see, I've got them on my phone today, comes from a gentleman who is asking about Guantanamo Bay and the Eighth Amendment. Does the Eighth Amendment have any bearing on anything that goes on in Guantanamo Bay?
Well, generally speaking, no. One of the big issues with Gitmo is whether or not it's covered by constitutional protections, generally speaking. And there were some cases decided that brought the individuals being held at Gitmo under a certain amount of U.S. court oversight, but not the full panoply of federal constitutional rights. The whole idea behind Gitmo is that those individuals are not in the jurisdiction of the United States judicial system, even though they're in the custody of the United States, and therefore that be subject more to the military tribunal rather than the civilian criminal justice system. Now, again, there's been some litigation that has allowed for a federal court consideration of their circumstances, but not to the point of being able to bring Eighth Amendment questions concerning, the conditions of confinement and questions of that sort.
Well, thank you. And Thomas Galliato asked, and that previous question came from Timothy, let's see, I just wanted to say his name, Timothy Taft. And Thomas Galliato asks, does the Eighth Amendment under cruel and unusual punishment cover concerns over holding accused people for extended periods of time? I think we may have already addressed this a little bit, but an example of this recently is the incarceration of a number of January 6 defendants who I understand in some cases have been jailed for many months before their day in court.
Well, you've already in this program addressed the protections of the Sixth Amendment. And so for those who are being held, and the issue is really one of speedy trial and whether or not someone is able to have his or her day in court in a sufficient period of time. And so the Constitution does protect us from being having justice delayed. But the question of what a reasonable extension of time would involve involves two parties. And so the courts will hear from DOJ in terms of an extension of time, but they'll also hear from defendants. And I've heard questions about unreasonable delays, but I'm not familiar enough with the facts to know whether the delays are at the request at times of the defendant so that there's opportunity to be better prepared for the case, or the government and the basis for why the extension of the period of time occurs. But there is protection in the Constitution against unreasonable delay.
Well, thank you. And then Mel Heinrich asks, I've seen where agreement with other prisoners of other countries that have an arrest warrant in America, prisoners were handed over on the condition of knowing that they would receive the death penalty as in Mexico. The offense by American law requires a death penalty. How can this be done when our law says that it is unfair? What laws do we follow in these types cases? Does that?
Yeah, these are all great questions, by the way. So this issue of international agreements essentially they come up in one of two ways. Either extradition agreements that cover all cases that will then be handled according to the agreements, and the partnering country with the United States may require that if they send a defendant to us, that defendant would not be subject to the death penalty. And we're able to agree to that if we believe that it's in our interest as a country to be able to get people back to the US. And then, of course, the same way it works the other way, too. We can add provisions to agreements where we don't want someone to be subject to a particular penalty in another country. But then there's an individualized set of circumstances that would be perhaps in cases where, under certain circumstances, with that particular defendant, there's an agreement to waive the death penalty if someone is brought back to the US. And the Justice Department has the authority to do that on a case-by-case basis. So that often comes up in these international agreements on extradition. And the question is very good, because it's the capital punishment is often an issue in those agreements.
Well, thank you. And then Dr. Braverman asks if there are ways, if sometimes the government bypasses the proportional punishment of Eighth Amendment by using administrative law. He says long procedures rotate judges. And then he also asks about just lack of proportionality in general with the Eighth Amendment. He says he's had clients who've had 7 years of so-called due process for misdemeanors, or facing, ruined publicity and ruined reputation.
Sure. Well, the Eighth Amendment is not a cure-all for all types of injustices that someone may suffer as a result of being prosecuted. As we said at the very beginning, it's the shortest of all amendments, 16 words, and therefore doesn't protect individuals from all of the potential harm that can be experienced in the process of a particular case. On the first part about administrative penalties, an excessive fine could come up as a civil or administrative matter. It again would have to be something fairly extraordinary in terms of its size, and in order for the court to step into that matter and not defer again to the penalty scheme that has been created for whatever administrative violation it was. But there is definitely a protection against highly confiscatory penalties. Let's say the EPA imposed $1 billion penalty for a minor environmental crime. Now, what would happen is typically that administrative case would go to a federal court on sort of a review or an appeal, and that's where that would get straightened out. But under the most unusual circumstances, if it didn't get straightened out and it went to the Supreme Court could say this is an excessive fine. It's just those are very few and far between, if not unprecedented, because the combination of looking at the fine scheme as being potentially within reason, but also mostly it's because federal courts oversee administrative bodies and can kind of straighten out when mistakes are made like that.
Well, thank you. And we are right at the top of the hour. We want to thank our audience for all the great questions. We're sorry we couldn't get to all of them today. We also want to thank our audience for making a few Giving Tuesday gifts while we were on the air. I saw one come in from Robert Spiegler. Thank you, Robert. We're now at, I believe, 62% of our Giving Tuesday goal. So we encourage you all to please go to our website, and if you can help us with a gift of any size for Giving Tuesday, we'd be so grateful. And Paul, thank you for being our guest today. It was such an honor to have you, and we just appreciate your great work, and just thank you so much.
Well, it's been a pleasure to be with you, and again, the wonderful questions and an excellent discussion about some complicated issues.
And
yes, and it's Janine. I just want to say, Paul, I thank you for your contribution to our country. and your great, brilliant mind. It was really wonderful
thank you.
spending some time with you, to
I
have someone
appreciate
of
that,
your
Jeanette.
caliber on our show.
Thank you for
Thank
saying
you.
that.
Thank you so much.
And so Jewel and Jorn, and I think Tova's had to go to class, and thank you all. And please join us next Tuesday at 2 p.m. Eastern for the 9th Amendment. Thank you.